You may be seated. Our last case this morning is case 13-1277, Bradley Walker versus the City of Toledo et al. Sitting for Justice O'Donnell is Judge Scott Gwynn from the 5th District Court of Appeals. Welcome, Judge.
Thank you.
All right. For the appellants, is it Mr. Lauk?
Yes, Chief Justice Laux. Madam Chief Justice, and if it please the Court, my name is Adam Laux. I represent the City of Toledo. With the Court's indulgence, I'd like to split time with co-appellant Red Flex of 9 minutes for the City of Toledo, the remainder for Red Flex. First of all, thank you for hearing this case. It's a matter we believe that has great significance not only to Toledo but to other cities of the state and to the citizens of the state. As you know, undoubtedly, this case involves a facial challenge to an ordinance enacted many years ago by the Council of the City of Toledo. That Ordinance 313-12 euphemistically is called the Red Light Ordinance, but it also involves photo enforcement of speed cameras. The challenge essentially asserts that by having an administrative process, the City of Toledo has usurped or otherwise interfered with the authority of the Toledo Municipal Court. We believe that that is absolutely not the case, and that the ramifications of allowing a decision such as the one out of the 6th District that does that would have untold consequence and establish a very negative precedent around the state. When you look through the exhaustive briefs...
Well, what would the untold consequences be? It's a legal issue, right? So,
certainly.
So, other than the loss of revenue, is that the untold consequence, or is there a overarching legal principle that would be the untold consequence?
It's the overarching legal principle. This Constitution Ohio currently has been around almost 100 years, and a principal part of that Constitution is the home rule authority of a city to self-govern. And a principal part of self-government, we submit, is the ability to set up administrative appeal boards to have quasi-judicial hearings on matters of local controversy. That's not unique to the City of Toledo by any means. The various amici and certainly the other briefs in this case point out countless incidents where the municipalities, through their legislative actions, have set up appeals boards to hear matters that sometimes involve violations of ordinances, sometimes they involve other things. They range from anywhere from taxi cab appeal boards in some cases. You have obviously civil service commissions, tax appeals boards. There's even a dance hall review board in the City of Toledo, which
Counsel, if I may, I think we're aware of all those things. I'm trying to figure out what we're here on today, on the broader picture. Are we talking about the existence of cameras or the methodology by which the fines are collected? Is the existence of the camera itself at issue in this case today?
I believe this court has definitively decided that issue in Mendenhall. It is clear that under the home rule authority of a city like Toledo, or in that case Akron, we can have these cameras.
So what stops you at that point from just processing the tickets as a regular red light ticket written by an officer?
Well, they're certainly not a criminal ticket. These are civil violations, the exact same as it was in the holding in Mendenhall. You'll recall in Mendenhall, the issue was whether or not the process by the city of Akron in having civil violations for these photo enforcement, and that involved the speed camera as well, photo enforcement, whether or not that violated home rule or violated the state's general powers on traffic enforcement.
So if I were to follow that argument, you're telling me that someone driving through a red light in Toledo in a residential neighborhood has committed a civil violation and not a criminal violation?
He's potentially committed both, just as this court considered in Akron. If a police officer were there and pulled him over and stopped him, a criminal complaint would be filed with the
No, that's not my question.
Okay,
my
I'm
question
sorry.
is, what would stop the city of Toledo from filing an action in municipal court saying, "Dear Mr. Smith, you went through a red light on Elm Street. Come see us Monday morning at 8 o'clock and we will show you the photo"? What would stop the city from doing that?
Well, because of the nature of it as being a civil complaint, I don't disagree that we could.
What I just described was not a civil complaint. What stops the city of Toledo from taking the photo, saying, "Mr. Smith, you went through a red light, you endangered the children, you're guilty of a criminal act, come to court, 8 o'clock Monday morning, we'll discuss it"?
I believe if we did that, we would, in fact, violate the jurisdiction of the court. We would be telling the court how to handle these cases. I think that the way we do it in this matter is we make available a quasi-judicial hearing for people to appeal. And if they appeal and they're successful, we drop the matter.
So, counsel, by keeping it civil, you're saying that does not run afoul of the jurisdiction and the responsibilities laid out for municipal courts?
The jurisdiction of the municipal court is unaffected by this ordinance.
There is a route that will take you to the municipal court, though, from this red light traffic camera, correct?
Oh, indeed.
And would you describe that for us?
Yes. Under the ordinance 313.12, there are two possible actions a person who receives a violation could take. They could request a hearing in front of a hearing officer, go to a hearing, and debate whether or not they should be considered liable under the ticket, or they can ignore it altogether. If they ignore it altogether under 313.12D3, I think, of the ordinance, the city would have the ability to enforce as a debt through a civil action, presumably in municipal court. If they appear for a hearing and the hearing officer finds in their favor, the case ends. The city will not go any further. If, on the other hand, the hearing officer says, "We believe you're liable," the city would have the option, but it would not be required to file a civil complaint in the municipal court. And that complaint would be like any other complaint, subject to the civil rules. I'd file a complaint, and the defendant, if they show up, would answer and have available anything that the trial judge allows. I'm not going to say that all trial judges would treat the case differently, but
all right, what happens if I lose in the administrative review as the owner/driver of the vehicle, and I want to take that further?
You certainly can under 2506.01 of the revised code, which is one of the troubling...
And where do you take it?
To the Court of Common Pleas.
Okay.
And in fact, that does happen with some, I wouldn't say frequency, but it does happen in Toledo with these ordinances.
And so the Court of Common Pleas is the appeal from a traffic camera citation?
Yes, the Court of Common Pleas has jurisdiction to hear appeals from administrative hearing officers, boards, and bodies under 2506.01. So not only would there be the ability to contest in municipal court should the city file in municipal court, there would also be the ability, if you went to hearing, to appeal that hearing under 2506.
So you're going to turn common police judges into traffic court. Is that right?
No, not necessarily. Common Pleas Court also has a jurisdiction for the dance hall review board. So I suppose, in a sense, we could say, well, yeah, the poor Common Pleas judge has to listen to whether or not a dance hall owner had his license wrongfully revoked. Or
how many violations of that ordinance have you had in the last decade?
I have to admit, since I've been with the city, I've only handled one. But the reality is not many of any administrative hearings actually get appealed. I don't think there's much threat of a floodgate.
Now, you said a person could just ignore it.
Yes.
And what happens then?
Then at that point, the city will send collection letters, as would any other person, or as it's not unusual in any suit. But if I wanted to garnish,
and do they notify? Do they attempt to ruin your credit as well by notifying the credit rating authorities that you you're a deadbeat on the Toledo
My
traffic
understanding,
ticket list?
my understanding is that, like any other debt, pre or post judgment, it could affect your credit. I don't have a whole lot of personal knowledge in the collections on these.
To your knowledge, is there any other case that is looked at 1901-20A1? That's a section that talks about the jurisdiction of the municipal court for any violation of an ordinance within its territory. So that there's that statute that says municipal court has jurisdiction, and then your statement that any appeal here would go to the common pleas court,
Yes.
mainly shutting out the municipal court. Is there any other case that talks about this?
First, I don't think it would shut out the municipal court, because I think 2506.01 does not preclude any other available appeal. I think at 2506.
Well, are you saying that there's a potential appeal to the municipal court?
Yes.
Okay, explain that to us, because I thought you had talked about an administrative appeal going directly to common pleas.
Well, for the city to get judgment, we would have to file an action in the municipal court.
But what about for the alleged offender?
The alleged offender would have available whatever jurisdiction the municipal court would have. I can't tell you the truth of the cause of action that they may have, but if they wanted to challenge the ordinance in the municipal court under Section 1901-20, and that would be something that would be their option.
But a direct appeal from the hearing that is held pursuant to the traffic ticket, or the civil action, I should
Yes.
say, goes to the common pleas court,
I believe that's the purpose of 2506.01.
just like any other administrative
Yes.
appeal.
Is that
Could
part
you,
of the...
could you, your city, enact an ordinance that would allow for that appeal from the hearing to go to the municipal court rather than the common pleas court?
I think that we probably could. Certainly it's not an issue here, as long as we did not attempt to preclude the Lucas County Court of or any common pleas court from whatever jurisdiction they have under 2506, Chapter 2506. So I believe that's of course a very good question. Unfortunately, not one that's involved in this case. But I believe that to the extent that the jurisdiction of the municipal court exists under 1901-20, that would allow it.
Okay. Are you ready for your co-counsel to have some time?
I want to take you back to your overarching implication of this. It would seem the question the Chief Justice just asked you would have overarching implication across the state. If the appeal from these is always going to be the common pleas court, then you've just thrown traffic into common pleas court all over the state.
Well, we've had this ordinance on the books since 2001, and I don't want to swear in front of the Supreme Court of Ohio, but I would guess with a fairly good guess that it's been maybe a dozen, maybe 16 over that period of time where an appeal was taken on 2506. I don't hold me to it absolutely, but I can assure you it's not been 100, it's not been 1,000, it's not been 10,000.
And the notice that goes originally, does it give notice of how that appeal process would take place under what administrative appeal rights the recipient might have? Is that part of the original notice that goes out?
The notice advises of the administrative appeal right.
But it doesn't talk about any court appeal.
No, and nor does the ordinance. We believe the 2506 appeal exists as a matter of law. That is
But the recipient doesn't know that from the notice itself.
I do not believe so.
So that may be one of the reasons we haven't had the appeals.
I wouldn't venture.
Who advises the recipient of this ticket if they lose on the administrative level? Who advises them that they have a right to appeal to the common pleas court in 250601?
The fact that 250601 exists as a matter of law, and that is.
The hearing officer doesn't advise them at the time they lose at that level?
I don't know. I do not know if the hearing officer does or does not.
Thank you. Counsel, you have nowhere near 6 minutes, so we'll see where you go.
I see my yellow light. Oh, yes. Madam Chief Justice, members of the court, let me go right to the issue of that seems to be troubling the court about appeals to the common pleas court. The court can make a decision that will tear into the fabric of the jurisprudence of this state and create clashes among statutes. Two statutes, 2506 and 1901.20, or it can choose what I would call pick Occam's razor and choose a simpler path that also makes everything flow and the statutes connect, and here's why. If we're talking about the jurisdiction of the municipal court, which is what this entire appeal is about, the assertion before this court is that administrative proceedings, whether they're photo enforcement or not, impede upon the jurisdiction of the municipal court because it shuts the courthouse doors to the municipal court. A jurisdiction of the court is invoked by the person who wants to go there. And there is nothing in this ordinance, unlike the Cups case, where there was an ordinance that said, thou shalt not go upstairs. Thou shalt not go to the court. That's not this case. There's nothing in this ordinance that keeps anybody from going to the municipal court. And to Her Honor's question...
How do they get to the municipal court?
They don't have to go to the municipal court, I guess is my point, Your Honor, because the precise question before this court is the municipal court being divested, stripped of any jurisdiction?
Well, you just said there's nothing here that keeps them from going to municipal court.
Because in theory...
I don't understand, after just listening to your co-counsel, what you're talking about.
And I'm trying to clarify that, Your Honor.
You're not doing a very good job.
Well, let me keep at it. If someone gets a notice of violation and they believe that there's nothing at that point from keeping them from going right to the municipal court and trumping the whole thing and asserting lack of due process, this whole thing is corrupt, there's nothing that keeps them from going to...
Are you talking about filing a brand new lawsuit in municipal court?
Because that's what the jurisdiction of the municipal court is.
Because they couldn't just show up and say, I've been cited for a traffic ticket, could they?
No, but when we talk about the jurisdiction of the court, it can only be to start a civil action. That is only what courts have jurisdiction over, is over civil actions.
So are you saying the process that you're advocating this morning is if I get this so-called civil red light ticket, I can go to municipal court and sue the city of Toledo?
There is nothing in the ordinance that keeps them from doing that. And that's the point. We're talking about if we're talking about a pure jurisdictional issue, is there anything in this order that actually prevents somebody from going into the municipal court? Just because there is an appellate process under a different statute that directs all administrative appeals, photo enforcement or not, goes to the common pleas court, does not mean, the court would almost have to find that statute impedes the jurisdiction of the municipal court.
So there's no reason to distinguish this administrative process, the civil administrative process, from any other civil administrative process, only because traditionally red light tickets have been traffic offenses. And since there's a new method of looking at traffic tickets, which is they're civil infractions when they're caught on camera, just based on the ordinance, we just need to move away from the concept of a criminal sanction, which you would agree, if it was a criminal sanction, you could not address that administratively. But
Absolutely.
if we can all agree that it's a civil sanction, and then it's a civil issue, and that will get you to this administrative process, which will get you through 2506 to the common pleas court.
There are 2 points, and one touches on what Justice O'Neill was asking about earlier. And I want to point out that every single photo enforcement ordinance, including this one, has an express provision that says if there's an officer on the corner of a red light and a camera's there, the camera clicks, the officer sees it, that photo goes away. There can be, as a matter of law, under the ordinance, no civil photo enforcement because that's criminal if the officer cites them. That's why there's a separation in these ordinances. And they're written this way in part because of Mendenhall. Mendenhall itself said the civil photo enforcement supplements. It does not replace the criminal traffic enforcement laws.
Are you suggesting in that scenario the officer could not use that photo as evidence at trial?
Actually, no. But what I'm saying is that there can be...
No, you're not saying that?
The officer in theory can, but The point is that there can be no issuance of a notice of liability. The entire notice of liability, the administrative process, goes out the door. And back to the other point Her Honor touches upon, and this is why, Your Honor, Justice Pfeiffer, this is such an immense issue across the state. Appellee says on page 21 of their brief that none of these administrative processes throughout the state, none of these are affected by the 6th District's decision because none of them involve ordinance violations. Absolutely wrong. If your grass is over 8 inches tall, you know what you're going to get in the mail? You're going to get a notice of an ordinance violation. Every single one of these, and we cite several in our brief, examples of administrative violations, administrative procedures established by ordinance pursuant to home rule powers that begin with a notice of an ordinance violation. And then many of them are just like the photo enforcement procedures. You ask for an appeal. You go to a hearing officer. You meet the hearing officer. Maybe it's like the people's court. But you have your day in that hearing, and then as a matter of 2506, you go to the common pleas court if you want to appeal. And if this court says that all of that administrative process, whether it's photo enforcement, nuisance abatement, towing, is no good because it has to start in the municipal court, you're going to have a massive disruption in this state.
Counsel, is there any other case that has looked at 1901 20A1 this way? Or is the 6th District the only one?
There is absolutely no court has ever held that, and it gets confusing because of that use of the term exclusive. No court has ever held what the 6th District has held. And I would also submit to the court the notion that if you look at that statute, I'm just going to touch upon, it kind of triggers a little issue of exclusiveness. There are 2 words, any, in that ordinance. In fact, they're in the same sentence. And it also says that a municipal court has jurisdiction over any misdemeanor violation. Well, and this court has held that in spite of that language, common pleas courts also have jurisdiction over misdemeanor violations. It's concurrent jurisdiction, so just because a common pleas court here's a matter that involves a misdemeanor doesn't mean the municipal court is divested of jurisdiction, which would have to be the logical result of the argument that you can't have appeals to the common pleas court.
But you can't have dual prosecutions.
No.
So it's an either or. It's not. They're not. And in that case, they are mutually exclusive.
Right. Those circumstances come up when you might have an indictment that includes both a felony and a misdemeanor. The court's held that the common pleas court can certainly has jurisdiction over misdemeanors.
Counsel, I'm still stuck on your original opening comments about nothing keeps you from going, the person who gets one of these, from going directly to municipal court. And I'm not sure what it is you say. Is it some sort of original action?
I suppose
challenging the constitutionality of the ordinance?
Well, that's what they're doing now, and that's what they could do. And I suppose the response is kind of a rhetorical question, which is, where is there? I mean, this is the point of the appeal.
And you start that in muni court.
And why couldn't you? Or why couldn't someone who wants to invoke the jurisdiction of muni court? Because the point of the appeal is that the muni court is divested of jurisdiction. There's been no answer. There's conclusory declarations from appellees that divest the muni court of jurisdiction. But how? And that's the question. How are they divested of any jurisdiction?
And that's where you get to the idea that this is a supplementary process now. An administrative process that didn't exist before has been created by ordinance.
Yes.
So it really does not affect the jurisdiction of the municipal court.
No, and in fact, this court in the Scott case specifically held that statutes involve the operations and jurisdictions of the court do not apply to administrative proceedings. Page 327, I think, was the court's decision. In Scott, this court's already held that administrative proceedings are over here. They're not part of a court system. And if they're not part of a court system, they can't be stepping on the jurisdiction of a municipal court.
Thank you.
Thank you, Your Honor.
Mr. Miley?
Chief Justice O'Connor, and may it please the court. What this case is about, it's not a home rule case, it's an Article 4, Section 1 case. And what the ordinance seeks to do is arrogate the municipal court's Article 4, Section 1 judicial power and take it and give it to the hearing officer. And along the way, they impair and restrict the jurisdiction of the municipal court conferred by the General Assembly under 1901-20. And here is exactly how that is done. I'd like to go straight to the ordinance. It's done in 3 ways. First, these tickets are not filed in municipal court. So the first step is We're not going to go to court. We're already circumventing the judge. We're already circumventing the rule.
Does that happen in other administrative citations?
Not when the issue is an ordinance violation and the General Assembly has not enabled that to happen. The parking violation exception proves the rule. Their argument basically renders the parking violation completely superfluous. It shows the General Assembly's intent that when we grant, we have the exclusive Article 4, Section 1 power. And when we say the municipal court has jurisdiction, which Toledo concedes throughout their reply brief that that's the case, what that means is the municipal court has jurisdiction unless the General Assembly says otherwise. Toledo cannot self-create an exception to an Article 4, Section 1 court's jurisdiction.
What about the Mendenhall case?
Mendenhall, here's what Toledo says about Mendenhall in their reply brief. I'll read it straight to you. The key issue presented in Mendenhall was different than the issue here. Mendenhall did not involve a claim that Akron improperly infringed upon a municipal court's jurisdiction. Mendenhall means that they can have a camera and they can regulate traffic. That's where home rule stops and Article 4, Section 1 begins. Yes, they have home rule powers, but the people in Ohio have checked those powers by enacting Article 4, Section 1, which this court has repeatedly said, from the Hunt-Spiller to Ramey v. Davis to Cups, up to the 6th District, and there is another court. It's Jodka out of the 8th District looked at this and struck it just as well. This court has repeatedly said that Article 4, Section 1 supersedes home rule. Here was the certified question in Mendenhall, Chief. Whether a municipality has the power under home rule to enact civil penalties for the offense of violating a traffic signal light or for the offense of speeding, both of which are criminal offenses under the revised code. This has nothing to do with Walker's challenge. And under Gordon versus Rhodes, it does not control that challenge. Here's what the court said in Gordon versus Rhodes. A reported decision, although in a case where the question might have been raised, is entitled to no consideration, whatever as settling by judicial determination, a question not passed upon or raised at the time of the adjudication. Mendenhall is a complete red herring. And here's where their merchant debt example breaks down. Taking their logic, Toledo could say, we have a problem in our city with unpaid merchant debts, and consumers aren't paying the merchants, but we don't want to clog our courts with it. So we're going to have a system where the merchant can send a consumer a notice of liability and say, you owe me $120. And if the consumer doesn't respond, the ordinance could say, we can take your vehicle. That's what D6 says. If you don't come see the hearing officer, they take and impound your vehicle and keep it until you come pay the penalty. Or if the consumer does respond, the merchant can decide for himself whether the debt is owed, and if the merchant says the debt is owed, he can, under their theory, the merchant can march right into court and say, court, enforce my decision. That's the only room for the municipal court under this ordinance is to enforce what the hearing officer does. So the only path to municipal court is if the hearing officer decides against you, then they go to court. It's not a trial de novo. The whole point of the hearing officer is to decide whether the ordinance has been violated or not.
But you agree that it can be appealed to the Common Pleas Court?
The Common Pleas Court 25061 is completely irrelevant for three reasons. This court has repeatedly held that a specific statute prevails over a general one. 1901-20 is the specific statute, the only specific statute that addresses the court's jurisdiction over ordinance violations. This is an ordinance violation case, therefore 1901-20 prevails over 25061.
So any municipality that has an administrative process to deal with an ordinance violation that's unconstitutional in your...
Unless the General Assembly has enabled it. 2506...
An example of the General Assembly enabling a municipal administrative structure.
Zoning boards are given certain hearings, certain powers. This is all in the 6th District decision. Nuisance boards, cities are general health districts. Things that relate to that, they have the power. The General Assembly has enabled that. The parking violation exception is an example of that. But the General Assembly said, to your point, Justice Pfeiffer, we're going to appeal that to the municipal court. The General Assembly does not want busy common pleas courts to be the arbiter of ordinance violations. That's why they enacted 1901-20. 2506-01 is for quasi-judicial determinations. The only reason this is a quasi-judicial determination is because they've taken it from the municipal court and given it to the hearing officer.
But, counsel, it seems that you're talking about the General Assembly giving the cities the home rule power that they already have under the Constitution. I don't see where Mendenhall doesn't have implications to this particular case.
Mendenhall, here's what Mendenhall says.
I'm aware.
You're the author. Here's what it means. Here's what it means. Mendenhall means that the city can have. The plaintiff in Mendenhall was actually kind of making a crazy sort of argument. The plaintiff was saying, you have to charge me with a misdemeanor. You have to. We're not saying that you have to charge someone with a misdemeanor. We're not saying that they can't have cameras. We're saying that if you have this, you go to municipal court and file it.
Could we talk about your plaintiff? There was the payment of the fine, was there not?
Yes.
Do we have any problem with standing here?
Absolutely not, Your Honor. Standing requires three things: injury, causation, redressability. Walker has alleged they have my money under this unconstitutional ordinance, and I want it back. This is no different than Santos, Judy, or Lycan. What they appealed and asked for a merits determination in this case. You can't do that unless they're standing. They are not raising standing. What your question really gets to is failure to exhaust administrative remedies. But if we're right that this is unconstitutional, we don't have to go see the hearing officer. This court has repeatedly held that an unconstitutional law imposes no obligation, creates no duties. So we're allowed to ignore the hearing officer under the Constitution, but under the ordinance, if we ignore the hearing officer, they can literally come and take your car and keep it without ever coming to court.
That's the problem I've had for about the last 10 minutes here, is it's being advocated that if you don't like what's happening, why don't you just go file an action in municipal court? In the meantime, by the Toledo ordinance, it sounds to me that if I've not appeared, they're going to go out and put a boot on my car.
That's absolutely right, Your Honor, that under the civil rules, they get 28 days to answer your case. Under the ordinance, 21 days, they have your car.
But, counsel, in that case, wouldn't that be an as-applied due process challenge?
No,
the trouble I'm having with those arguments is our propositions of law relate to authority in a broad way, and whether there's a jurisdictional problem. So are we even being asked to look at these individual provisions and say, for example, the notice that you argue in your brief, to say the notice is inadequate. In that situation, if I get one of these, if I don't receive my notice but I'm subsequently punished, don't I have an as-applied challenge?
I think that was in the ACLU briefs. What we're saying, the problem with the notice is it's a combination of the notice.
Well, I guess, but my point is that issue in front of us, and I don't see it in the propositions, and nor would the impoundment provision be in front of us.
It's not. It's in an indirect way. It's relevant to what the standing question was. They've put people in a conundrum if we're right that this is unconstitutional, because if you ignore it, they take your car. That's why the payment doesn't bar his standing. The only way the payment does is it solves the conundrum in the most economically efficient way. But they shouldn't be able to raise their ordinance as a shield to take that money, and the conundrum, or as a sword to take the money, and the conundrum that they've created as a shield to keep that money. That's what Santos stands for. That's what Judy stands for. That's what Lycan stands for. So it's before you in an indirect way, only it impacts upon the issue of standing, I believe, Your Honor. Back to the 250601,
So just to clarify on that point, if we were to say we think we do not agree, or we say that in a broad way this provision or this set of provisions is constitutional, but we say nothing about individual provisions, and those are reserved for another day.
I don't see how you could do that, because it's the individual provisions that are issue. It's the not starting out in court. They say the shall be heard. D3, I believe it is, says that the appeals, already by the time you get to the hearing officer, you're the appellant. There's no way to dispute this before an elected judge. You're the appellant at the hearing officer level. That, they say the ordinance violation shall be heard by the hearing officer. This gives exclusive jurisdiction to the hearing officer. The judge will never decide whether the ordinance is violated. And the merchant debt situation, the only thing when they come back to court on that, again, that would be under 1901-18A1. That's the municipal court civil jurisdiction. A1 says the court has jurisdiction in the same manner as the county court. So you go back at the county court jurisdiction statute, and it says exclusive jurisdiction under $500. There's the problem. The merchant debt doesn't solve the problem. They're up against the same Article 4, Section 1 problem. They've preempted the judge's ability to determine whether the ordinance is violated. They take the judge's power and they give it to the hearing officer every single time. And the common pleas court appellate jurisdiction does not mean the hearing officer has original jurisdiction. There's many times where there's appellate jurisdiction and there's no original jurisdiction. For example, municipal courts have jurisdiction not to exceed $15,000. But any decision of a municipal court can be appealed to the intermediate appellate court. Under their reasoning, any municipal court judge could issue a $1 million judgment entry and have subject matter jurisdiction to do so just because it could be appealed. Original jurisdiction doesn't follow from appellate jurisdiction. The 250601 argument is a complete red herring. It's 1901-20 that governs, Your Honor. Mr. Linsmith talked about 293103, concurrent jurisdiction over misdemeanors. That's because there's a statute that gives the common pleas court its jurisdiction. If there was a statute here, or if there was an exception, like the Parking Violation Bureau exception, that said the municipal court has jurisdiction unless it's a Parking Violation Bureau case, and unless it's a camera case, then yes, there would be concurrent jurisdiction between the hearing officer and the municipal court. But there is no statute. They're in the wrong building here in Columbus today. They have a political remedy to go across to the State House and ask for an exception in 1901-20. The meaning of Article 4, Section 1 is they cannot self-create an exception to an Article 4 court's jurisdiction or judicial power. That lies solely within the province of the General Assembly, and this court just held.
What about Mr. Lauk's original statement about the three examples he gave? I think taxi cab, dance halls, civil service, those situations. Would those be impacted?
If that's just an example of them trying to bootstrap their own ordinance by comparing it to other ordinances, we got to
saying that would not affect any of those.
If they say here, I think under those ordinances, if you want a taxi cab license, you petition the city for a license. They can have licensing boards. We have no problem with that. We're not saying they can't have a licensing board. What we're saying is if someone then operates a taxi cab without a taxi cab license, and that's a municipal code violation, then that's filed in 1901-20. Justice Cupp, you're exactly right. If they catch something like this...
Justice O'Neill.
Justice O'Neill, I'm shocked. Wow.
Can't ever dig out.
Justice O'Neill, you're exactly right. There's nothing preventing them from taking this picture to municipal court. We're not saying that they can't do that anymore. We're not saying that a police officer can't use a radar gun. But if a police officer has a radar gun, he takes it to municipal court. This 1901-20 requires the exact same thing here unless the General Assembly creates the jurisdiction.
So you don't see this as a supplemental program?
No, it's not a supplemental. It says appeals.
I mean, it's a civil. It's not a criminal.
1901-20 makes no distinction. And the only exception in 1901-20 is for civil, for parking violation tickets. Those are civil. That's the only exception. 1901-20 says that the court has jurisdiction over any ordinance violation. The court will never decide whether this ordinance was violated. They made it impossible. The hearing says...
Are you saying that Mendenhall would not be affected, that if we were ruled in your favor, we would not have to do anything to Mendenhall?
You would not have...
We basically said home rule allows the cities to have this type of program.
Home rule, the question you answered was whether they can provide a different penalty than what the revised code provides. So this does not impact Mendenhall. Mendenhall actually supports us in one very important respect. Mendenhall also says that they cannot alter statewide traffic regulations. This ordinance does that, and I'll tell you how. The revised code allows for a right-on-red situation. Toledo, if you look at the ordinance, if you cross the line, even if it's a right-on-red, you're guilty. There's no provision for a right-on-red. And you know what else the ordinance does?
Have they enforced that?
Absolutely, I believe they're
The
enforced.
right unread,
It's
the right unread violation of is a traffic camera issue?
That's what the ordinance says. That's what they are enforcing here on a daily basis. What else it says is that if you exceed the speed limits in 333.03, you're guilty. So they've borrowed the speed limits of 333.03, which are presumptive speed limits under 333.03, and they borrow them and enforcing it as if they're per se limits, which
can be challenged at the hearing, correct?
No. That's a constitutional issue. The hearing officer has no jurisdiction.
So this hearing officer only decides, is it your car and were you behind the wheel?
Exactly. And the General Assembly has said the municipal court has jurisdiction over that. The only reason the hearing officer can say this is because Toledo has said it. The General Assembly under Article 4 needs to provide that. Otherwise, home rule would swallow whole Article 4, Section 1 when the relationship is exactly the opposite, Your Honor.
Counsel,
Article 4,
as
Section
I
1
understand it,
supersedes.
I think you're answering Justice Lansinger. As I understand, the Mendenhall case is an Akron case, which did start this legal fantasy that traffic violations are civil violations, but they still go to Akron Municipal Court, correct?
No, I believe that those are before a hearing officer in Akron. But the issue, here's Toledo's brief. The key issue presented in Mendenhall was different than the issue here. Justice Lansinger, Mendenhall did not involve a claim that Akron improperly infringed. Mendenhall doesn't mention 1901-20 or Article 4, Section 1. Sorry about that. It has no bearing on this issue. This is governed by Cups, by Ramey versus Davis, by case law that has gone on for 100 years.
Thank you,
Your Honors.
Counsel, you've used all your time. You may take 30 seconds.
The General Assembly adopted 2506 and gave jurisdiction to the Common Pleas Court to accept appeals from any administrative proceeding. The General Assembly adopted 1901-20 that gave the municipal court jurisdiction over any ordinance violations. This court can interpret those statutes in a way that they clash and conflict or that they make sense. And, of course, the basic rule of statutory construction is you read them in a way that makes sense, which means that nothing in 2506 violates 1901.20, which is essentially what they're suggesting that this court do. Mendenhall is...
No, they're suggesting this is what Toledo did, is set up the clash.
Toledo only adopted an ordinance that they're allowed to do under home rule pursuant to the authority of Mendenhall, and Columbus has a vacant house and foreclosure ordinance not authorized by statute, but under home rule powers. It has the exact same administrative proceeding as photo enforcement. As one simple example, and there are dozens of those. And so the proposition...
There's dozens of examples of ordinances that are exclusive to Toledo, not sanctioned by the General Assembly.
Correct.
That take a case that in maybe other jurisdictions would be before a municipal court, and they put it before a hearing officer? Is that what you're saying?
Yes. That
Okay.
happens all the time.
All
There are
right.
hearing officers adopted by home rule, not by statutory authority, but by home rule powers. And I believe I used up my time.
Thank you very much.
Thank you, Your Honors.
We will take the matter under advisement, gentlemen, and you'll be notified of our decision. Marshal, will you adjourn court, please?
All rise. Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.